Healthcare options for more than 1 million South Carolinians is now in the hands of the U.S. Supreme Court.
Yeah, justices heard arguments Wednesday over whether state authorities can block Medicaid patients from seeking treatment at Planned Parenthood.
Queen City News anchor Savannah Rudisell joining us now with a closer look at this case. Savannah, good morning.
Hey, good morning, guys. The bench of the nation's highest court seemed to be divided during the 90 minutes of oral arguments in the South Carolina-based dispute. Now, this is an appeal of a federal court's ruling that the state cannot bar Medicaid patients from getting treatment at Planned Parenthood clinics. Now, several questions from the justices focused on the language of the law, as Medicaid rules allow for patients to get medical assistance from any, quote, qualified and willing provider. Attorneys for Planned Parenthood argue that thousands of people considered low income around the Charleston and Columbia areas see providers for things like birth control, physical exams, and cancer screenings. Lawyers for the state argue that no public money should go to the organization for any treatment, as it's the nation's largest provider of abortions. Protesters from both sides gathered on the steps of the Supreme Court Wednesday morning as South Carolina's case comes really during this wider push to defund Planned Parenthood.
The American people don't want their tax dollars being used to prop up the abortion industry.
This is about general, preventive, basic health care.
In South Carolina, about $90,000 in Medicaid funding goes to Planned Parenthood each year. Now, total Medicaid costs for the state reached nearly $9 billion in 2022. A decision from the Supreme Court is expected later this summer. Back to you.
All right, Savannah, thank you very much. Appreciate that. And joining us now this morning, Chief Legal Analyst Khalif Rhodes to talk more about all eyes, even the governor of South Carolina up in Washington for this. And we're hearing, we're still waiting on how they rule, but Khalif, we're hearing that some of the language is very important. When you go back to this small section of the Federal Medicaid Act where it says a patient may obtain, those two words, may obtain any type of care from any provider of their choice. Why is language so important when it comes to certain lawsuits or challenges?
Language is extremely important for every lawsuit. I mean, but this one in particular, we had a couple things. And so let me start at the beginning. Anytime I listen to these oral arguments, you're trying to hear the questions that the justices are asking because they already have their mind made up. They've already talked to their clerks. They've already looked at all of the briefs that have been submitted by the parties that are involved. They looked at the amicus briefs from parties that are not involved, folks that are just submitting things that want to have their opinions heard. And so they, at this moment, when we get to oral argument, they have to either fine-tune their thought process or debunk some of the things that they're thinking or support their argument. And so we know from the very beginning, when you listen to Clarence Thomas, when we listen to Alito, they're extremely conservative with their thought process. And regardless of what comes in front of them, they're kind of already stuck in their side. It's going to be hard to remove them. Everyone else is kind of a wild card. I think they will go on the lines of the argument of the day oftentimes and can be persuaded outside of political affiliation. But yesterday you heard two that came back and kind of showed their hand. Started with Neil Gorsuch. He said it seems that Congress could hypothetically say that individuals are entitled to benefits but not want to create a right to enforcement. So you recognize that he's saying that these folks don't even have a right to sue. You don't even have a right to be here. He's talking about standing. So if I'm looking at my crystal ball, I'd say he's ruling against this for sure and saying that South Carolina can do exactly what they want to do. So then you look at Kavanaugh. Kavanaugh said, I'm not immune to magic words. Magic words are great. Magic words, I'd like to see it something like, a right, entitlement, something like that allows these people to know they have a right to be able to bring a claim. So if we're counting, we're down 4. We really just need one person to say, look, I am saying that South Carolina is allowed to do this, and this is already kind of dead on arrival. As Savannah said in her intro, the district court ruled in favor of Planned Parenthood. The Court of Appeals ruled in favor of Planned Parenthood. But it seems like this Supreme Court is on the tipping point of ruling against Planned Parenthood and in favor of the states. Those magic words are the rights. And the last thing I'll say is they're looking to avoid the floodgates. I've never actually used the floodgate. I've seen them before at dams. I've seen them at other places. But oftentimes you're asking for magic words. Floodgates are what they're trying to avoid. They don't want to have a situation where everyday random citizens are saying, I want to sue, I want to sue, I want to sue. And they're saying that Congress anticipated that. And that's why they didn't add the language of you have a right to sue.
See, I want to talk about the state's ability to have discretion to give funds because that's who decides how much funds you can get for Medicaid. But when it comes to standing, Khalif, that's the thing that I think is important when you talk about the Supreme Court. It's not who is right or wrong. if you don't have the standing to bring this case, it doesn't matter, right?
100%. Like if you have not been the person that's injured in fact, that's normally when the case is removed. Like I haven't been harmed by you, and so I don't even have a right to bring a claim. But then also, if you weren't contemplated by the drafters of this statute as someone that they anticipated bringing a claim, and that's what this discussion has kind of harbored around. It's saying that you weren't even thought of to bring these type of claims because we don't want millions of people bringing claims every day. And they said this would be a waste of resources and a waste of time, and litigation is a huge waste of state resources. So I think this so far is tipping towards ruling against Planned Parenthood.